I'm Sylvia Idowu. Welcome to another edition of Handy Law. So we are looking at wills today. And the governing act is the Wills Act 1837 and the wills laws of the different states in Nigeria. There are three types of wills: the non-cupative, the privileged will, and the statutory will. We will start with the non-cupative. This is an oral directive given by a person in anticipation of death. To be valid, it must have been made in the presence of at least two credible witnesses. It must have been made voluntarily too. The testator or testatrix must have testamentary intention and a sound mind. The beneficiaries must be specifically named and described to be identifiable and ascertainable. And the properties also must be specifically named to be identifiable. The next one is privileged wills. A privileged will is an informal will which remains valid even though it doesn't meet the usual legal requirements. Here, the legal requirements have been reduced in order to allow certain persons to quickly make a will. It could be in writing, it could be oral. So who are these persons that fall within this category? We have sailors or seamen at sea, crew of airlines, soldiers in actual military service. However, under the Nigerian Armed Forces Act or the Air Force Act, the military personnel must fulfill two conditions. The first one is that it must be in writing. The soldier must sign before a witness, and that witness must be a military officer or a medical officer. Then we have the statutory wills. These are wills made in accordance with the provisions of the Wills Act 1837. The features are: it must be voluntary, it must be in writing, it must be signed and attested to by at least two witnesses. That is, the testator or testatrix must sign in the presence of two witnesses. The testator or testatrix must have sound disposing mind. The will must adequately describe the properties and the beneficiaries of same. The executors of the estate must be named. The testator or testatrix must have testamentary capacity. That is, be 18 or 21 years of age, depending on applicable law. How to sign a will? It's very important to note that for a will to be valid, the testator or testatrix must sign and date the document in the space provided below in the presence of at least two witnesses. After the testator or testatrix has executed the will, the witnesses will also sign in the spaces provided, printing their names, occupation, and addresses so they are easily identifiable. Any alteration to a will must also be signed or initialed by the testator or testatrix and the witnesses. But really, the best way to alter a will is to execute a codicil. This is like a miniature will. The codicil will, of course, reference the will and be executed in like manner as the will. In fact, all the characteristics or the features of a valid will also apply here. So where do you keep a will after execution? The best place to keep a will after execution is to lodge it at the probate registry in the city where the will is made. The advantage here is that the process of lodging the will takes care of some possible objections that may come up in future. For instance, was the testator or testatrix of a sound disposing mind? Was the will made voluntarily? The court would ensure that these things are in place before approving lodgement. But of course, people have been known to keep their wills in different places. Some people use bank safety deposit boxes. Some use safes in their homes. Some lodge it with their executors or trusted friends. The most important thing is that people should know, or people you trust or the executors should know that there's a will and where they can easily lay their hands on it, so that your beneficiaries are not left scrambling or looking for ways to settle the estate. This is as far as we will take wills. In the next edition, we will look at trusts as another means of settling your estate. In the meantime, don't forget to like, share, and subscribe.